down. So without any further ado, it's a real joy to welcome Associate Professor Andrea Borghini and Professor Enrico Bonadio to the stage. They've been there already. I can control slides if you want.
No, I can touch it.
Thanks
so much. Thanks so much.
Please do take away.
Christian and Elaine and all the Center for Food Policy to help and support to organize this event. And this is.
Do one more click.
Oh, maybe yeah. Okay. Yes. So I mean, let's talking about how this project started, because the idea of writing together, Andrea and I, this volume grew out of conversational exchanges between the two of us and a legal scholar specialized in intellectual property law and a philosopher specialized in food, recipes, and so on and so forth. So our views on these subject matters developed in very different ways, addressing apparently different issues, right? So when we first met was December 2018, so basically 6 years ago. And because Andrea invited me to a conference in Milan, a conference about philosophy of food. He knew about my scholarship because he heard about a presentation of mine on IP protection of recipes, and therefore he invited me to the conference to explain my research. And after the conference, we realized that our respective areas of expertise complemented each other, right? And could be fruitfully merged to close some gaps in the literature. So it was a nice conference. We became also friends, not only colleagues. But after the months after the conference, we started talking about these issues, this intersection, food, philosophy, and IP more in depth, about recipes, about packaging, about food brands, about patents protecting manufacturing techniques of food products, and the many ways, anyway, food intersect with IP. We discussed about, trademarks, brands in the food industry, how brands are important for the food industry, for both the big corporations and also the small restaurants, the family-owned restaurants. We spoke about geographical indication, which is a very important intellectual property right, protecting the names, not the geographical name of agricultural, products, food in particular. We talked about patents protecting biotechnological GMOs, plant variety protection, also industrial secrets, because several chefs, they use secrets to protect their own recipes against competitors, right? And even copyright, which might be perceived far from this world, but indeed, as we will see later on, copyright might, in theory, also protect recipes, right? And also corporations' packaging of food products are also very often filled with copyrighted works on the packaging, right? So you can see all IP rights do intersect, have the capability of intersecting with food. So on my end, of course, in our conversation, I was stressing how IP rights aim at incentivizing and rewarding inventiveness, creativity. That's why they are granted. They are monopolies, basically, right? When you grant a trademark, you grant a monopoly over a name. When you grant a patent, the state gives a monopoly to the inventor, which can be enforced against competitors. So it's a monopoly, right? Which, however, aims at incentivizing creativity, innovation, and in case of trademarks, at regulating a trade, because consumers need brands in order to make educated purchase choices, right? Trademarks are protected also for protecting consumers into buying the right product, into not being misled to buy the wrong, right? And creativity in general, innovation really applies, regards specific aspects of food. A recipe invented by a chef the name, the brand given to a particular food product, the logo, which is often used by companies to distinguish and to promote the product. As I said, the new innovative manufacturing techniques, if you go and check the databases of patent offices where that data are public, you can see how many food processes are protected by patent. And we will show one slide, the RAM. I mean, there is innovation there, right? There is investment in innovation by food companies, by innovators. Packaging, the importance of packaging for food and packaging is protected by IP, the brand, the trade address of the product, and there are legal battles. We will see later on some of them. Of course, on the other hand, Andrea and I also agreed on the fact that there might be overprotection of IP, right? Food companies, for example, tend sometimes to register as a trademarks generic names, which is very, 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 very dangerous for competition because you cannot monopolize a name which should be available for everybody in the market, right? So the monopolization of expression, words, packaging elements, the shape of a product, as we will see, may harm consumers, and not only competitors, but also consumers, which have less information available to decide and to make that educated purchase choice, right? Then also, I mean, IP, we discussed a lot about that. IP may be abused and may be obtained to incentivize research, which is controversial. The GMOs, debate is very well known. It has been around for ages, for decades, and still it is controversial. Patents are granted protecting GMOs, certain specific GMOs. Of course, so we talked about positive and negative aspects. Also, from a global south perspective, especially GIs are important, right? We have some examples of, later we will show some of them, agricultural products produced in very specific areas in some developing countries. Well, getting a GI, getting a monopoly over a geographical name, which is known for the quality of the product they are produced, may help economies in those countries to grow, right? Especially when it comes then to exporting such products with that protected name in the big markets of the world, Europe, especially Europe. America, no, because America does not protect so strongly geographical indications. And we will give some examples. So in one of the sections of the book, we have the last section, which is called empowerment. Empowerment for the global south, because, and this is the positive aspect of IP. IP being used by local communities or local areas in those countries to monopolize a brand, which is useful then to export and to conquer areas or market areas in the big markets. Now I would leave now to you can
no, you can just go to the next slide.
Yes. Okay.
So one of the in the previous slide, actually, we were talking. There was a note there saying challenges. The way I come to this topic is, let's say, orthogonal to the one that, to some extent, or to the one that Enrico takes. So if from the perspective, the point of view of a legal scholar, you can think of IPs as being the main entry point right into the food. So the way in which you look at the food is through an element that regulates the identity of something that somehow, maybe I'm exaggerating here, but you almost already take for granted, right? So you think there is a food product there is a recipe, or there is a process, and then you're just trying to regulate it. I think as a philosopher, coming to food, to the study of food from the point of view of what is called in philosophy, theoretical philosophy, of metaphysics, philosophy of science, semantics, we don't take for granted the it, right, the product, or whatever it is that we're talking about. So if you're trying to regulate it, as a philosopher, I wonder typically, what is the it? What is it that we're trying to regulate? And a lot of these questions is fascinating concerning also IPs, the use of IPs, or other forms, we will talk about that too, of protection or labeling that somehow is a distinguishing element for the product, where really the terrain of where our conversations met. So if you take, for instance, a product that we will mention also later on, kimchi, right? So kimchi is something that really crosses borders. It's very hard to regulate through, through IPs. In fact, it hasn't been regulated through IPs and probably will not be, right? But so how do we think about the identity of a product like that on a global scale, like on a global market? What are the elements that might be IP-like and those that are not? And if you take some other products like that we often talk about also throughout the book through different cases, for example, champagne, like a wine, or we have another product that actually appears in 2 cases, which is honey, Manuka honey. You can come to negotiate or think about the identity, precisely of champagne or Manuka honey, from different angles, different points of view of producers, of precisely consumers, of regulators, policymakers, right? So what we were trying to do in the book is to see how matters of really identity, product identity, and product, whatever shapes how we interact, how different stakeholders interact with them, and how we should regulate them, how these conversations can come together. And so one of the choices we had to make in the volume was to think about the structure of the volume. We actually devoted quite a bit of time discussing that. It took, I would say, probably more than a year, maybe 2 years to come to a structure that we could kind of agree upon. And what we decided to do was, so not to organize the cases based on the type of IP dispute. So like, is this about, copyright, or is this about a geographical indication? But rather to look at how IP elements interact with other elements that really matter to scholars working on food, other scholars, so not just, of course, philosophy scholars, but for example, food policy scholars, people in food studies, or people that work on agriculture economics, for instance, right? Or they try to clearly develop better foods, and stakeholders. For example, if you take consumers, that of course should be really at the center of this. So how do consumers, for example, come to see or can make sense of some of the disputes about IPs? If we had to make an inventory of these disputes, how can we organize them? This was the question that we were asking. And so the type of answer we tried to provide was to provide to give an inventory that was somehow speaking to maybe also a lay person and to different stakeholders that also use IPs, or they have to somehow come to see the importance of laws and regulation, but at the same time, they're not all about that, but they actually care about maybe the identity of the product. Okay? So we came up with these 8 parts and 8 categories. And one thing it should be said is that the goal, or one of the first goals of the books, and the reason why we decided to do this kind of book and not something that is more, let's say, even theoretical than this, is that there was no general overview of the cases concerning IPs and food. So that's what we tried to do, right? We said, let's start from maybe 30 cases, 25, then in the early book proposal, we had 36, and then we quickly moved to 50. There could have been maybe 75, or we say, next edition, maybe 100, hopefully. But certainly, there are quite a bit of them, and it's complicated how to put them in in an order, in an organized way, to lay them out. So we have a first part that talks, as you can see here, about images, where image here is really meant as a very general term for all sorts of ways in which foods may appear to us. And then we'll go through some examples. So I'll leave it just at that. But you will see there are 6 cases that we chose for this part. Then the second one is about whether we are doing something, we're dealing with something that is a generic term or is it descriptive of a specific term. This is an especially interesting, I think, case. For example, in a lot of disputes in the US, they're even still ongoing. There is the question whether a certain name of a cheese is a generic term that should apply to, anything can have that name because it's generic. Before I mentioned kimchi, it could even be something that you might think is a generic, or take it something like pizza, that's clearly a generic term or used as a generic term. So when is it that a term becomes a generic, and when is it that instead is descriptive of a specific product that could be tied to a land, to a people, to a process, and so on and so forth. Then there are cases of what could be called language traps. So where language really plays a trick for very specific functions that might happen. If you think here of vegan dairies, for example, or it's an example. So you see something that is vegan milk, and you think, oh, this is just like a trap. So you think it's milk, but it's not milk. And so it could confuse consumers, as of course happens. But Ethiopian coffee, you think is from Ethiopia, but from where? And is it really like that? So it's something about where the language really plays a trap for a specific function. Then we have something dealing with procedures. So changing procedures, how we make food, how companies can make food. Then we have something instead related to recipes or menus, like menu scraping, or can you copyright precisely a part of a recipe or an entire recipe if possible, and issues of creativity also within recipes. Then there is a whole other set of cases that are really important as well that deal with boundaries, especially geographical boundaries. So we have here, we'll see basmati rice, right? Or rendang. Today we were at the Boro market, they were selling rendang. Is a product between Malaysia and Indonesia that is contended, right? And so does it belong to one or another? The problem is that it traverses, it crosses boundaries, right? And so how do we resolve those disputes? Biotechnology, that was already mentioned by Enrico, and then the last one is also one that Enrico mentioned, is cases of empowerment. We wanted to highlight all those areas where maybe even IPs can have the possibility of bringing, precisely a form of empowerment to communities that maybe are not such. One last thing before we go to see some cases that I think is relevant to say is that not all of the cases that we review are legal disputes. And that was also part of really the intersection between let's say hard law and what we call also soft law, also in the book, in the scholarship as well. This is really important. I think what also for me was really nice to see the continuum. So some cases we can tackle by looking at what happens in a court and what could happen in a courtroom. But some other cases that will require diplomacy and different kinds of diplomatic tools. So before I mentioned rendang, clearly that's a case that is resolvable through diplomatic tools. Kimchi is another one, and there might be other ones still. And when issues are not resolved through diplomatic tools and they try to be brought into court, sometimes the situation becomes especially complicated. Think of these days, we might talk about this in the Q&A, the kebab, for example, dispute right now in Europe, or of whether, what's really the recipe, the identifying elements, what are the identifying elements for kebab? And that's being debated in a court, right, in Europe, but it's something that could be settled also diplomatically in other terms, right? And so some of these issues, they really are not, they don't belong just to hard law. In some cases, they belong to both hard and soft law. In some other cases, only to soft law. And within doing this, something that might be relevant to consider also later on, if you think about empowerment, often we don't think of IPs as a form of empowerment, but there are lots of labels that consumers are used to see. For example, Slow Food has introduced some very important ones, and I think they've done also a lot of good in the food market, but they play a function that is often, I would say, similar from the consumer's point of view. They, put a label that is often considered as a quality mark for a consumer. That it's not the legal aspects of it, but it's just what this symbol, this term, this color, whatever it is, the code that is used, right? The sign that is used to mark that conveys to a consumer or to some other stakeholders. So this is part of the conversation that we were trying to look at. Yeah, I guess now we should look at some
cases. We have picked up some cases. Of course, we could not look at today all the 50 cases, but we have picked up some of them. So the first one in the first category, images, is about geographical indications. Queso manchego. You may know this product is a cheese from Castilla-La Mancha in Spain. It's a very, very good cheese. And they have, the consortium have registered the GI, the PDO in Europe, queso manchego. They were able to enforce the GI queso manchego against a competitor which was not using the name queso manchego, but it was just using this packaging, forget the name, just the packaging with the typical Cervantes Don Quixote scenery, right? With the horse Rocinante, with the windmills, the typical setting of the Don Quixote. And the Court of Justice of the European Union sided basically with the GI owner by saying, even if they have not copied the name, adopting a packaging which reminds consumers about the La Mancha, no, the Castilla-La Mancha scenery is a form of evocation, which is an infringement of GI. So it has been a very controversial decision because they didn't copy the name, the GI, which is the subject matter which is protected. Similar case was this other cheese, which is the Morbier. You may know the Morbier cheese is French. It's a French cheese. And again, they protected as GI the name Morbier, which is a geographical area, right? Local. Well, they were able to enforce such monopoly, not against those who were using Morbier, but just against those producers that were marketing the cheese with the same shape and the same the blue line in the middle. Because consumers are, the average consumers in Europe, the consumers of cheese, is aware of the fact that the Morbier has the line, the blue line in the middle, and therefore marketing a blue line cheese like this, produced not in the relevant area, would be an evocation of the GI. Again, very controversial decision by the Court of Justice because, as I said, it's the name which is protected, not the shape of the product. What the Court of Justice here has done in both cases is to expand disproportionately, I would say, the scope of protection of the GI. I mean, GI is a name, right? It's a sign. It's not the shape of the product. Another case was the Ferrero Rocher in India, right? There was no trademark here because there are also trademarks protecting the shape of the product, right? But even without a trademark registration, if the shape of your product is so recognizable to consumers that it's capable of, allowing consumers, oh, that's Ferrero Rocher, right? And Ferrero Rocher does have this very distinctive shape, right? The packaging, the way the chocolate is wrapped. And they were able to stop an Indian competitor, Golden Passion, no? Yeah, which was basically marketing the product in the very same packaging and shape. So this is not a protection of the name, as you can see, it's the protection of the way the product is presented to consumers. The requirement for the protection is that the packaging or the shape must have become distinctive, recognizable by consumers. So consumers, they know, oh, it's Ferrero Rocher, right? If they do so, they can obtain this kind of monopoly and protection. Second category, you have mentioned it before, these cases. The first was, again, a Court of Justice of the European Union case, Champagne Sorbet. Of course, you may understand that here, the consortium for the champagne product was quite annoyed by the fact that this sorbet manufacturer was using the name champagne on the was calling the product champagne sorbet. But the Court of Justice here of the European Union decided a few years ago, 2018, that in short, long story short, if the product does contain that ingredient, and indeed the sorbet in question was made by using champagne, right? And if of course, if the percentage is so substantial, not just 1%, of course, well, third parties can use the protected GI for descriptive purposes. Well, again, a borderline decision, because of course, this decision, as you can understand, has left many GI owners disappointed, because they say, look, anyway, but you are still exploiting the evocative power of my GI, even if you are trying to describe to consume. And then the feta case, you can see on the right the feta cheese. I mean, in America, it's generic, right? And there is a new world, old world battle here, because the Europeans would like the Americans, the Canadians, the Australians to stop using feta for describing a cheese produced in Ontario or in Melbourne or wherever, right? But in Europe, it's protected feta. And by the way, protected as GI, but it's not a geographical name, it's a legal fiction. Feta is not a name of a Greek town or a Greek region, mountain, whatever. No, not at all. It's a traditional name which actually comes from the Italian language, fetta, which means slice, right? But historically, centuries after centuries, it has become a specific name which reminds consumers about the Greek origin of the cheese. Anyway, some German, Danish, French producers, they were using feta for their own cheese. The Greek complained, there was many decisions until 2005, 20 years ago, the Court of Justice said, no, feta is still a geographical indication, indirect geographical, because it's a legal fiction, which can be used only by the Greek, right? But, you know, these cases, especially for cheese, I mean, cheese producers in Europe, they need to be careful to prevent such phenomenon from occurring. The genericide is called the phenomenon. The protected name becoming the generic name of the product. They need to be careful, they need to spend money, right? To, for example, writing to dictionaries publishers. Because if your GI ends up in a dictionary, it's bad news, right? Because it means that the process of the trademark becoming generic, the GI becoming generic, is already on, let's say. The third category is about language traps. I don't know, maybe you want to introduce some cases, Andrea?
Yeah, here we decided to highlight this case of Beyond. Maybe some of you, I mean, maybe most of you are familiar with Beyond products. And what is interesting of the company here is a different strategy, right? Because you're thinking here of food futures, in a sense. Foods that in some cases, they don't even yet exist, right? They have preventively sought, you know, IP rights on names, on lots of names of products that precisely deal with the protein market, right? In this case, these products that I put down, I got them online. They're all sold in some parts of the world right now. You know, the Beyond Smash meals, tenders, burger, and then there is chicken, salmon. But they try to already preventively have patents over also precisely future products. And what we wanted to highlight in this case is precisely the possibility of having a whole universe reconstructed under, in this case, a company brand, right, and a company name. So you reconstruct the whole universe of protein market through the lenses of one company, right? So this is one use of IPs that we could envisage maybe for future foods, especially when we think that, for example, in this case, proteins, but in some other case, could be for other types of, of foods, food products, but proteins in this case, they are all made through processes that are, that heavily depend on some technologies, on some specific technologies.
The curiosity of this case, there was a case in Japan, right? Because Beyond Burger was registered in Japan by this vegan company, and they enforced the Beyond Burger trademark against a meat producer. By saying, no, it's our stuff. You cannot use it because you are a meat producer, so you cannot use Beyond Meat, right? So that was the curious thing. Sorry, I interrupted you.
That's it. And then there is the case of Prosecco versus Prosecco, which is still pending. And it's a situation where precisely even like a street sign suggests, Prosecco and Prosecco can be often used kind of interchangeably, depending where you are. But of course not for the wine products. And they are very different wine products, actually. But nonetheless, it could be, the argument was made that maybe some consumers could precisely mistake one for the other. And so this is a pending dispute.
Between Italia and Croatia, actually. Croatia is trying to register. Prosecco is already registered as European GI, the Italian Prosecco, and the Croatian, they are trying to register Prosecco for their own wine, which is a completely different product. Is a sweet wine to have with dessert, with pudding, basically. So it's a different market from Prosecco. But still, of course, you may understand the Italians are quite annoyed by the fact that Prosecco might be registered on the other side of the Adriatic Sea, right? So it's still pending at the European Union. Yeah. Then the fourth category is about procedures.
Yeah, and so the first one is it's a type of procedure for producing rum that shortens the aging from years, like 2 years typically, to like 1 week, 6 days, as they say. So you make a product that is arguably of comparable quality, but certainly it could be, there are a number of resemblances in terms of experience, really the flavor experience and the biochemical components. It's completely transformed by the invention of this distillery that is actually located in California. In case it's in America, has production facilities in different parts of the US. And so in this case, the question is whether these are really the same products or not. So chemically aged rum, is it really the same as non-chemically aged rum? And
they got a patent.
Yeah, they got a patent on this. And so the answer for the US court was yes, for the US Patent Office was yes. But we wanted to precisely highlight that it's an interesting...
Because patents, let's remember that patents are granted for inventions. The definition of invention is a solution, an original solution to a technical problem. So here, what is the problem? You need to wait 2 years. It's too long, right? Let's shorten to 1 week, 2 weeks, to try to get the same kind of quality, right? So you in order to, of course, increase productivity, you can increase the production by shortening. Probably rum lovers might not like this product. I don't know. I'm not a rum expert, but the quality might be different. But that's what patents do. Patents incentivize this kind of innovation because then you have a monopoly of 20 years, right? You are able to prevent others from exploiting that. That would be an interesting research, Christian, patenting food, analyzing all the patents, because if you go and check the patent databases, you will find lots of patents pending, protecting different way of manufacturing, in more innovative way of manufacturing the food. Yeah. And then we have the Parma ham.
Yeah, the Parma ham. This was about packaging, precisely, food packaging. Yeah, it's here in England.
Which is a phase of production, of course. And basically, Asda, which is an English distributor, right? They were selling Parma ham, which is a GI, protected GI, but they were packaging themselves in England the ham. So they were buying the ham from Parma, from Italy, slicing that, but then the packaging was made here in England for, you know, reducing costs, basically. The Parma ham consortium complained, started the legal action by saying, no, you cannot do that, because otherwise you cannot use the name Parma ham, because not all phases of production have taken place in that particular area. And, you know, PDO, the kind of GI, requires all the phases from the beginning until the packaging to be made in the same area. And the Court of Justice, of course, sided with the GI owner by saying, no, you need to do everything in the area. Also, the less, let's say, substantial phases of production like packaging. So very strict. You know, when it comes to GIs, the EU is very strict. There are some specifications that you need to, as GI owner, you need to comply with, the method, you need to use that method. It's a very well regulated. That's why the Americans, they don't like it, no? This kind of bureaucratic, you know, intervention.
No, I'm just saying these are the cases that are really fun from a philosophical, because it makes you think, what is, you know, the identity, what is the condition of identity? So one could think, what is slicing? But slicing, for example, for a lot of consumers makes a big difference. You know, the way you slice it, how the sensitivity to it, and then of course, even if you think of the preservation, right? So packaging it at the place of origin could maybe ensure some of those aspects, but it's really interesting to think about that as an element of you know, preserving the identity. You know, otherwise you're not actually consuming that thing, but it's something else.
Yeah, I agree. Of course, I am of this opinion, but I understand the counter argument by saying it's very regulated, right?
It's really philosophical.
From the American perspective, for example, it would be unthinkable. No, the market should decide. You cannot really oblige me to slice in a city rather than in another city, right? Or to packaging. But, you know, that's the way it works in Europe, because the idea of having this GI protection is not only, of course, to protect the economic interest, of course, it's about money, but also the gastronomic cultural heritage, right? In Europe, we have, I mean, even in England, in Scotland, with Scotch whiskey, there are several GIs in this country as well, of course. But, of course, the demand for GI protection originally came from the South European states, France, Spain, Italy, Greece, Portugal, those are, but then extended north of the continent. Okay, the fifth category is about mainly recipes and menus and stuff. There are 2-3 cases where we analyze the copyrightability of recipes. In some cases, it has been denied, no? Such as in the lamb beef Godiva chocolate, because basically the US court there said, well, what is a recipe? Is a set of instructions, right? So it's merely functional. And in the world of IP, functionality is protected by patents, right? It's patents which protect functionalities, procedures to make a product. Copyright protects artistic, literary works, right? The creative expression. But in another case, in the following case, it seems that the case law is slowly changing, because wherever the recipes is made with expressive flavor content, that's when it may become copyrightable, not as a set of instructions, as a process of making something, but as a way of expressing a concept, right? So, for example, a book of recipes is copyrightable because it does, right, express some form of creativity.
Yeah, and the Cowboy Chow was this book by Judy Barbour containing recipes, which was allegedly scraped by another author, you know, by Head. And in this case, well, the court didn't claim that they were fully copyrightable.
It left the window open. Okay. Yeah. If the recipe or the list of recipes contains some expressive element, is not just a set of instructions, Well, it could be theoretically eligible for copyright protection.
Yeah, yeah. And then we have the cupcakes up there, which are from instead the case of the Magnolia Bakery, this relatively well-known bakery, also because it features in Sex and the City in New York, in the West Village, where one of the previous employees at the bakery opened another bakery nearby and started doing swirls, the pronunciation. So basically decoration of the cupcakes, they were very similar. And so the owner started precisely copyright infringement, and obtained actually the right to have these signature words that can be found only on those cupcakes. So right now, if you go to New York, and they actually sell them pretty much globally, like they ship them, you can buy Magnolia's Bakery, then you can make sure that that swirl is only on them. And it's one of those interesting products where the creativity goes to the benefit of one also small producer. Another very famous one recently in New York, it wasn't really a dispute that was fought in court, as far as I know, but it's the cronut. Some of you might know the Dominic Cancel, this very famous pastry chef. And so he invented, so to speak, the cronut, like the croissant that is fried like a donut. And some other producers, for example, donut producers, say even in California, they started making something that was like a cronut, but they cannot call it a cronut, right? Because the name in that case is what was copyrighted, but it's an invention, it's a pastry invention where you can't claim you have made a cronut, even though you kind of did make it, but you can't claim there is a cronut. And that's really tied to one specific bakery and the invention of one specific person. So those are interesting cases that make us think of whether those elements of creativity, of course, can enjoy a form of copyright.
Then, the 6 categories about boundaries. Andrea has already mentioned something. There are products, agricultural products, food products that are, produced, grow in different states, in neighboring states, right? So we pick up, for example, the basmati case. India applied for a GI in Europe, no, for basmati. The application has been opposed by Pakistan, of course, because Pakistan has a vested interest. They also produce rice that they call basmati. And they have, so in India it's protected as India basmati, and in Pakistan it's protected as Pakistani basmati. Also in Nepal, they produce basmati close to Kathmandu. So it's spread, as you can see. And they're still pending in Europe. We don't know. Probably, I mean, the Indians might have more chances because India is bigger and they presented with the application, but it's still pending. So we don't know with certainty who is gonna win. There were rumors before to file a joint application, Pakistan, India, but that idea did not fly. Probably they're not very, relations are not so. Yeah,
it's one of those cases where diplomacy could help.
Diplomacy
for sure,
could
but
help. They are both
hard,
nuclear powers.
Of course. Now, then we have these products that instead have similar history. These are processed foods, like kimchi, so coming out of fermentation processes, where, of course, kimchi has enjoyed a number of disputes. One of them concerns some other fermented vegetables. They are probably quite different, one would say, but in some context, they tend to be called under the same name. And so in this case, would be fermented vegetables that come from the area of China that borders actually with Korea, in this case, South Korea. And so it's po chai, this fermented vegetable. Many of you also, if you go to Chinese restaurants, even here, they might put on the table in some cases. And so in some parts of China, they call kimchi Korean po chai. And so this has been part of the dispute. The question is, that's not po chai, it's actually kimchi. And so even for the packaging of products, right, this is not something that has been settled in court, but has given rise to a number of diplomatic issues. Similarly, actually, with other fermented vegetables that are in Japan, and is constantly coming up as an issue. The interesting part also about kimchi is that, so kimchi is probably, as I was suggesting, maybe going towards genericity, even though maybe it's never gonna get there, who knows, is still open. But kimchang, instead, the practice of making kimchi, that's recognized by UNESCO as a practice that is typical of South Korea in this case, even though one could say maybe it's extend to other parts of Korea. But the practice of making it is typical of an area, according, this is the UNESCO list of intangible cultural heritage, but not the product itself, right? And also some of the reason of this is the kimchi. There is another case that we review in the book concerning processing. A lot of kimchi for the international market is actually produced outside of South Korea, historically in Japan as well. So it's certainly product whose production has been multi-located, let's put it like that. And then here we have just another case, the one of Rioja wines, where Argentina, in this case, won a legal dispute against, is it one? The compromise. Yeah.
Because there are two Riojas.
Yeah.
I mean, Rioja region in Spain, which is very well known for a good red wine, Rioja wine, which is protected as GI in Europe. But Argentina does also have a region called Rioja. You know that migrants from Europe, Spain, when they migrated to America, they used to choose pick up names for the new word, same names as European towns, European regions, European. And the issue that in Argentina, they also grow wine in that grape wine in that region, Rioja, Argentina. So there were some international dispute, who can use Rioja. The administrative tribunal in Argentina ended up deciding that both, you can use it, stop litigating, please. You use Rioja Spain, and you use Rioja Argentina, both. So consumers are not confused, right? Which is a sensible, reasonable way of achieving a compromise, right? To try to avoid consumers' confusion in international markets, because think of consumers going to the supermarket, they saw two Rioja, different, but if the term sign Argentina and Spain is well visible to consumers, confusion will be avoided, right? In principle. Then there was another case we didn't put here, was about Pisco. Chile versus Peru. Yeah. Pisco is a brandy, grape brandy, and originally from Peru, but Chile objected. There was dispute. I mean, between the two countries, there were also territorial disputes in the last century. So they both registered in Europe, PGI, one PDO, and so there is the same of dynamic here, right? Boundaries, different regions, neighboring regions producing the same product, claiming to be able to use the same geographical name. Then, part 7, biotech, of course. We couldn't leave this debate out, because when it comes to food, of course, the use of biotech is widespread. It has been so for decades. And we know all the issues, morality, health, environment protection, raised by the commercial exploitation of GMOs, genetically modified organisms in agriculture, right? But what about patents? Patents are regularly granted for biotechnological processes and products derived from biotechnological progress. But in order to get a patent, the general rule is that in order to get a patent, human beings need to, conduct technological steps, right? An entirely natural process of developing plants cannot be patented, because it's the nature which does the job, right? It's not the human being which, finds an original solution to a technical problem, right? But in this case, before the European patent, the two cases, the first was tomato and broccoli case. They basically, two biotech companies that developed different processes, biotech processes for the production of, they were essentially natural processes for producing broccoli and tomato. So they did not invent anything, they found it in nature. And they claimed the patentability of the products directly obtained by using essentially biological processes. And it was very controversial because the European Patent Office in 2015 granted the patent for the broccoli and tomato obtained by essentially biological processes, which the nature triggers, right? So very controversial cases, so controversial that in a following case, very similar, the pepper case, the same European Patent Office 5 years later, so in 2020, refused the patent for this kind of products. Products obtained by essentially biological processes, which makes sense because, as I said, here the human being, the technology is not really used. You don't use genetic engineering, for example. You don't change the genetic structure of the plant. No, that's how usually GMOs are produced, no? By inserting a foreign genes or DNA sequence in the tomato, in the soya bean, or in order to get a property, no? To be more resistant to ice, to rain, no? To guarantee more productivity. No, in this case, no, it was essentially natural. So how can you claim property rights to monopolize something which the nature gives us, right? So there is also a philosophical angle here, right?
Yes.
About the appropriation, monopolization of something which is made by nature, right? Of course, if the human intervention in sense of technological steps is introduced during the phase of production, of course, patents should be available because patents should reward human inventiveness, not a natural phenomena, right?
Yeah, this case, the only thing I wanted to add maybe here, it's a good point to thank you also one of the people that wrote a postface, you know, to the book, David Foreman, who actually worked as an attorney for decades in the US, you know, and he gave us also valuable feedback even on this part. And then a preface to the book was authored by Michael Roberts that works at UCLA, and he has actually done extensive work on legal aspects of food in all sorts of areas, including IPs, but yeah.
And the last but not the least, the empowerment section, as we have said. From more a global south perspective, as we said. So, especially GIs. Probably GIs is can we say that is the most global south friendly IP right, because it aims at protecting the gastronomic heritage of a certain area, right? And you know, when there are several emerging countries in Africa, Asia, Latin America, which are rich in biodiversity, which can offer traditional products, products whose manufacturing technique has been passed from generation to generation, right? Conserved and stuff. And the GI protecting the name of a certain area amounts to protecting that heritage. Of course, it also gives you a monopolistic tool to extract profits, of course, because you are able to prevent others from using that name. But by doing so, you're also able to give value to the heritage, to the century-old, sometimes century-old tradition. So we have inserted the first case study we have looked at is a red bush from South Africa. The first African PDO GI registered in Europe, right? Just a few years ago, 2021. The same goes for the Demerara ram, a PGI, a GI for a ram protected in British Guyana, okay, in South America, the Caribbean area, right? Café de Colombia, another PGI for Colombian coffee. Also, as you can see, in addition to the name Café Colombia, they also have, put a logo, no, to penetrate markets, right? They have, they have chosen a typical Colombian farmer with the mustache and the hat and el caballo no me acuerdo el nombre. Donkey, yes, donkey, exactly.
Yeah, and then the other one is the Madre de Casamance, which is actually doesn't have a GI yet in
the Francophone Africa, yeah.
But yeah, and this is a product that is linked, for now has had recognition only in Central Africa, in a few countries, a consortium in Central West Africa. But it's a product that is actually harvested, and it's linked also to communities, especially of women. A lot of the people working, they're invested, in preserving this product, are also women, and so it has represented like a frontier of what some, a direction, of some products that could seek IP protection for markets that are linked to precisely to specific ecological conditions. Another one that we didn't put here is the cabrito de tête, which is goat meat, basically from, in that case, it's just Mozambique. Yeah. So yeah, maybe we can go to the next, and so just after this we have just the cases, the future, the cases to come.
The cases to come, yeah. We don't have the slides, but the last...
Yeah, we have, remember the two slides, yeah. So we have
Chef GPT, the future.
Cases. Yes, the future, he forgot. We have, we have so future cases that could concern precisely patentability or less, or copyrightability, who knows, in any case, different kinds of IPs over recipes, and over robotized, automatized production kitchens. This image here is from Molly Robotics. It's actually housed as a company here in London, makes these very sophisticated automated kitchens.
Expensive.
Yes, it's for very high-end cooking, maybe homes, so it could be dining halls. It's not clear yet, the market. But then there are some vending machines that do much simpler, in a sense, items like a pizza. When a couple of years ago, over the summer, I think the first pizza vending machine was introduced in Rome. There was a controversy, because people were claiming this is not pizza, it can't be pizza. But certainly one could think about some of these vending machines making products that some people could claim an identity over, and in some case, some form of intellectual property, being part of the dispute. And then we have even one more slide, right? There is that concerns other cases. So it's something that Enrico has also studied quite a bit recently, which are NFTs applied to restoration of food products.
Some restaurant chefs, the most famous ones, they have already started tokenizing their recipes, right? NFTs is a kind of digital token, digital asset, where basically you create a digital copy, or in this case, the recipe. You create like 100, 1,000, 2,000 limited NFTs edition, and you start selling them. There is a market for that. I mean, mostly for artworks, digital artwork stuff, but it seems collectors are, I mean, especially at the beginning now, the trend is going down, but at the beginning, 2021, with the start of the pandemic and the restrictions, people could not, go out. And so the digital collection started. The NFT craze started in that period, with the people spending a huge amount of money for what? For a link to a digital image that you can find online on Google. But that is there is a kind of aura. The famous chef, Collicchio, creating 100 NFTs for their fans, go and buy, that spend money to buy these digital copies of something that you can find on Google, basically, right? it's a hype, let's say. But you know, famous chefs, they have started doing that.
Yeah, and then some restaurants, like in this case, the Fly Fish Club, used NFTs to buy basically the access, like an annual access to the restaurant. So you can show up with your NFT and you can get entry to the restaurant through that. And you can also rent it to others, so you can rent it for a night. So basically the entry to the club is granted to
the NFTs create this sense of belonging, right? The NFT minter, the artist, the chef, the famous football club, the fashion house, or the musical band creates NFT in order to fidelize their customer base. And if you buy and collect NFTs, you are a member of a special club. That's the idea, right?
Yeah,
you can laugh. You can laugh because
many brands. It's
a bit incredible to see how people have spent millions to buy something you can find in Google just to show off and to tell, I have the NFT of this big you know, football team or fashion house or famous chef.
Yeah, and then instead a separate category of issues might arise from image generators, right? Probably a lot of you have been seeing because they've been around for at least 1 year or over the social media, right? But by now, if you Google for a recipe, chances are that you'll find the image associated to the recipe that is actually not of a real food, right? But it's something that was generated by a computer. And there are issues of how did, of course, the image got generated, if it got scraped from, you know, which sources and online, and so what we should make of that, and how, you know, whether that could confuse people of the identity again, or what the source of the image, and so on and so forth. Okay, so
this was an hour.
Yeah.
Thank you so much for your attention, and we welcome questions, criticisms, comments.
I'm just going to switch on the audience microphones. So the audience microphones are now live, so everybody can be heard in the room. We have 6 questions already lined up online. Okay. So, but again, let's just take a moment to breathe. Shall I ask one of the ones from the online while you guys are just thinking and thinking about what you want to ask as well, if that's okay? So we have 6 to choose from. This is a really hard choice, but Gerald, you know, who's one of the students on a master's in food policy, I feel this is a nice one to start with. What is the philosophical difference between wanting to share creativity, e.g. recipes, and wanting to protect creativity? So sharing versus protecting using IP, how does that work?
That's a good question. From a legal perspective, I mean, from a sociological perspective as well. In the kitchen, chefs have traditionally been sharing recipes between themselves. I mean, most of them, not all, most of them. And this might be perceived as antithetical to IP protection, right? Because, and indeed, there are just very few legal action taken or threatened by chefs. There are just few, very few. Why? They don't take action, chefs. Of course, they might be annoyed by the fact that a colleague copies them. Of course they are. But the way they react is not to file a case before the court. The way they, I mean, historically, maybe now it's changing, but historically, the way they've done so, reacted is to rely on social norms. For example, negative gossip on social media. That's a powerful way of reacting because, you know, the chef which was copied then pays a reputational damage, right? Because of that. And now in the world we are in, if you do post something in New Zealand, everybody in the world can see that, right? So historically, the category of chefs has been put by IP scholars in the so-called IP negative space. What is this IP negative space? It is a space of creativity where people create, chefs, graffiti writers, magicians, comedians, without IP protection. They don't need. I mean, historically, now our research, future research will focus on that. Maybe in this era of Insta food, of Master Chef, probably there might be changes, no, in the sense that chefs might start looking at legal tools like copyright or patents. But so far, at least in the past decades, there has been a lack of interest because of that, because of this element of sharing. Most of them, not all, because some of them, they have used NDAs. No? NDAs are non-disclosure agreements. So especially the most famous one, sometimes before allowing you in the kitchen, they make you sign an NDA, right? Whatever you see here, you cannot disclose it everywhere, anywhere. But not just a few do that. So there is this kind of sharing ethos, sharing attitude in the community of chefs. They don't want, I mean, most of them don't want to protect it. Philosophically,
No, I think we shouldn't add, we have also several questions, but one, maybe from a philosophical, let's say, theoretical, reflective point is that protecting clearly is polysemic, right? And sometimes when we protect, we do it for excluding, right? In the sense that we exclude others, but in other cases, protecting is also synonym, related to valuing. So sometimes protecting might mean, if protected species is not a species that you want to exclude others from, actually you want to value them, right? So in that sense, if you do protect, for instance, a recipe, what you might be doing is valuing it, right? So if you think of, this is what I mentioned early on, I was saying hard legal tools versus softer, but a lot of if you take a project like the Arc of Taste of Slow Food, they are not highlighting recipes, but mostly products. But it's really for what's the best way of protecting those products is to highlight them and assign them a value. And so in some cases, even a form of the IP protection could be a way of valuing it, but only if it's really achieved with a certain purpose, right? So, for example, depends who's granted the license, to use it, and in which ways can it be enjoyed and shared. So maybe the cronut, for example, that I mentioned before, many people don't view that as the best example, protection of something that you have invented. But if you have something that instead it's a risk of getting lost because its identity, specificities could get lost, then there could be a way of protection, could actually be through introduction of an SDG or some other strategy that. Right.
Okay, let's move.
Can I do one more line before I go, Giorgio?
Yes.
Is that okay? So Giorgio's got one, but just to follow on from that. So another one of the online comments was just highlighting, in a world of globally homogenizing diet, is IP a way of protecting these different things we love, dietary patterns, recipes, ways of, is this the way we need to do it for future diets?
To guarantee diversity, let's say, diversity of diet.
So preserving these food cultures, geographical food cultures, recipes, is this how we prevent an international homogenization? Sorry, hard questions, I know.
Well, yeah.
One thing that underlines, I think, the whole scope of, we started this project, I thought, as a philosopher, precisely, I would try to find answers to very general questions like this. And then I started realizing, we said this also in the introduction, that of course there are so many myriads of perspectives, courts, legal systems, legal perspectives. If you go to in the US or in Europe or in South America, in Central Africa, you have actually different legal frameworks, of course. And so even the way in which they think of IPs or protection is different, right? So it's hard to think of a global perspective from the point of view of food justice that can be readily applied to courts. And that's, I think, a first point that is important. Having said that, so I think for me, even coming at this from philosophy, but probably more from, let's say, pragmatist perspective, it's really important to look at the specificities of the items we are talking about. So the Mante de Casamance case, from what it seems for now, is that it's really a product that is still within a community, is still within some forests, it's harvested seasonally, and it's just the fruit that is used for making some very specific products in their area. And so it seems to advance forms of agroecology, of community, agriculture. So that's an interesting case in which maybe we can use this for protection. Right?
GIs.
But in some other case, it's a GI, right? And it could be even here in Europe. In some other cases, maybe that's not the way we want to go, because the communities are located in different areas. The production is much more complicated. The technologies involved in that are much more. So we really need to argue, I think, in that sense, case by case. It's very hard, at least for me, to have one answer that will fit, because otherwise we'll be thinking that all food products or all recipes are the same. But I don't think they are. We really need to look into the specificity.
If there is an intellectual property right which protects diversity, that's geographical indication, right? Because feta producers, they prevent other people from using feta because they want to protect the way feta is made. You are able to use feta if they produce in those parts of Greece, and if you use milk from goat, not milk from sheep and stuff, right, on cow, right? So probably the most diverse, the most appropriate IP right for protecting diversity, specificity is GI, right? Avoiding an homogenization of terms of brand. I mean, think a world without GIs. I mean, Americans, they could produce champagne, and they could call champagne wine produced in Wisconsin.
Or they do.
Well, under the TRIPS agreement, which is the main international thing, they shouldn't. Then they do. Okay, they do it. That's why Europeans are worried, but they could. They shouldn't. Let's say. Let's go there, because they have signed the TRIPS agreement.
We go to that question before you'll come back. Would that be okay?
Yes.
Do you want to go, Georgiana?
It kind of connects with the first question received. I was wondering whether it is always wise for producers to be this strict in protecting names through legal action. I was wondering whether it might backfire economically, because like if you think about it, like the resonance of names can be still seen as a marketing tool for these products. And that does, like, if you think about, for example, the case of the champagne sorbet, it's not like the people who want to buy the sorbet are going to want to buy the champagne. So there's this sort of resonance in the name that can still help the popularity of the brand. So I was wondering whether this strict approach can backfire against producers economically. Like also, if you think about, I don't know, maybe the case of Parmesan, it's like people from Wyoming are not likely to buy the Parmigiano Reggiano or Grana Padano anyway. So it's like, you know, the allure around the name, the popularity of the brand. I don't know if the question is clear.
But those names you have mentioned, Parmesan, Feta, those are in America, in Canada, Australia, they are considered generic name, right? They don't mean anything to the average American consumer. They don't know Parma is a town in Italy where the cheese is made, and they don't know Parmigiano comes from the Parma. But they are nevertheless capable of attracting customer base, lots of customer base. There are some statistics, I mean, some in US, if US producers had to cave in European demands and stop using Feta, Parmesan, Gouda, Gorgonzola, all these cheese producers in America, they would lose huge amount of revenues. It's an economic fact, because they would have to repackage and to re-educate, or educating for the first time, consumers there, right? Because they are used to those names as generic names. So I think these names are capable of attracting customer base and are capable of guaranteeing revenues. Then you mentioned the Champagne sorbet case. Basically, your point is that probably that kind of product does not damage significantly the consortium of the champagne, the French champagne in France. because consumers, I mean, they are different products, right? I mean, if consumers buy the sorbet, they can still buy the champagne. So there is no, but there is also the evocation of protection, the protection of the evocation. And here it's the protection is more a protection against unjust enrichment, right? It's not that your activity as a competitor has damaged my loss in terms of lost sales, but you have basically used a form of property which is my property, and therefore you need to give me the profits that we have made, right? That's the idea. Not as a compensation, but as, you know, you have used something which is mine. Of course, the counter argument would be, yes, but we needed to describe the ingredient. And there you need to look at how, for example, you have used on the packaging. If you have used, you know, in a descriptive, neutral way, you might, you know, get away with it. But of course, if you have used the word champagne with a big font, with the colors in order to attract consumers, that's different, right? That might really go beyond the descriptive use and instead ending up being an evocative use. Why do consumers buy that sorbet? Because you have highlighted so much the term champagne, which is evocative anyway. Consumers, they are not confused. I'm not saying that they are confused yet, they're not confused, but they nevertheless buy the product, that sorbet, because you are using in a very highlighted way the term champagne. Right?
But they have economic benefit because you bought the champagne from them, so they've made economic benefit from it.
Well,
No, I mean, they want everything. They want their cake and eat it, right?
It will be a double dipping, right? It will be in your.
I'm French. No, but it damages the brand because it's not a luxury product, the
Yes.
zombie. So it's basically all that money they put in advertising is just down the drain because they're associated with a product that's too cheap.
Exactly, because this kind of sorbet is sold in very low level channels.
Yeah.
And you know.
So it's a price point issue rather than.
And also the packaging's not pretty enough. It's not gold. It's not got supermodels.
Consumers, I mean, but their consumers might be confused, I don't know, by saying, look, champagne, they have a license in their own.
If it's a lower level market, then the rich people aren't going to see it anyway, so it's for the brand. That's my view.
Yes.
So now we go on to champagne because I think it's what you all most.
Yes.
I cannot see any moral justification why a campaign started in the 1950s by a body called the Société des Fabricants de Vin de Champagne, who discovered they were making wine in upstate New York with méthode champenoise, which was not an invention. I mean, it's not patented. Méthode champenoise. They discovered they were making it in New Zealand. They now make excellent champagne in Tasmania, where I was last February, and they can't call it champagne. They have to put méthode champenoise, and they know exactly. We all know exactly what it is. Any consumer knows what it is. Imagine the French had invented chocolate, and no one else was allowed to use the word chocolate because they wanted to package champagne. They wanted to pretend that the product only could come from one particular small area of France. We would laugh them out of court, surely. And this whole thing is a ramp. By some manufacturers, by the Parma ham slicers and the champagne manufacturers.
No, I disagree because I think this is a confusion on identity, because you're implying that the identity is a brute identity when actually it's a social identity. So all of the legal systems are protecting social identities, not brute identities. So it does make a difference where it's made or what the packaging, because they're all contributing to the social identity of the products. So for instance, if you were buying peanut butter and the Pope fell in, and there was the Pope in your peanut butter, even if there was a tiny amount of the Pope, it would still matter to you that the Pope had fallen in your peanut butter because it's a social identity.
And the food safety risk.
So if the Pope or the Prime Minister fell in your peanut butter, even if it was a tiny amount of the Pope, it would affect the social identity of your product. However, if the same amount of protein that came from an insect fell in your peanut butter, you probably wouldn't care because of the social identity of the product. So,
but you would again care because of the food safety rules. Just highlighting
what
that.
if you've boiled the ingredient or something and it's safe?
I'm even less persuaded by the. When you go to Tasmania and you buy a bottle of, or you go to England, which we haven't mentioned much, and you buy a bottle of English champagne,
Yes.
you know what it is. You know exactly what it is. It's not about protein content. It still has a cork in it. It comes out. It tastes. Indeed, it wins competitions on blind tasting on champagnes. I'm sure we can make bourbon in this country. The best whiskey now comes from Japan. And the Scottish whiskey people fight it, but they gave up because it's a simple product. And the Japanese make it better and win all the blind tasting contests.
So I'm just going to let our speakers talk, because we've only got about 10 minutes left before I catch you and respond. I would also highlight, this is why I love online webinars, but also in person, because the online audience is behaving really nicely, having a wonderful conversation. We've not forgotten you online, it's just we're having fun in the room. I've switched to the classroom mode of camera, so you guys all online can actually see what's happening in the room, so they can see all of you now. If you guys want to respond to this at all, I'm just keeping a little bit of balance. You just came here to see.
It's nice to have the audience.
I don't know if we have other questions to hand. Otherwise,
Well, we've got 4 more online. I'm sure there are more in the room as well. Just would you like to respond to that before we continue? Happy to continue afterwards if we wish to.
One of the things that emerges from this is really, again, the complexity of some of these issues. One thing I can say to this last part of the dispute is that yes, for sure, people know what it is to some extent, but to the point that Tessa was making, you could think that if you can identify a community where that product somehow really originated, resonated, they tended to it for a long time. I don't know that this is the case of champagne, exactly that. But suppose that there is such a community, then to have a recognition, whether this is through an IP or it is through some other maybe professional recognition or cultural recognition, but having that certainly is meaningful, right? We apply this maybe to Monte Casamance or maybe to some other products. Maybe we could apply this also to something like champagne. But it's certainly verging oftentimes these days, with cases that are quite problematic to explain, even to a consumer, like to a child. You have to say, of course, this is champagne. Like if I describe it to my child that is 6, you say, but that's champagne. And I'll say, no, but you can't call it champagne. It's, why is that? But certainly it's not French champagne. Like everybody would understand that. And it's not related to maybe a community. And there are, for sure, towns, producers in Champagne where there is such a strong culture around the product that clearly there is something about their region and that deserves specificity. But whether it deserves to be the only one using the term, I don't know. But certainly French Champagne or some other specificity, one could argue for that, and maybe. So it's where also we can find a compromise on that in terms of diplomacy. But the issue of the backfiring also, I think, is really fascinating. We could come back to, and it could happen not just with IPs, but also with general products. Sometimes we mentioned this also in the book. The first product that, one of the first products that the also Slow Food Protector highlighted was the buffalo mozzarella in southern Italy. And in a way, it kind of backfired. It's not an IP, of course, but it was a recognition, a symbol for produce. And in a way, it changed completely the food system, right? So the ways in which it's produced, who's entering the market, there was so much more demand suddenly. So not having their legal protection also brought lots of other actors into the market. So one has to think in general, what does it mean to highlight so much a product? What happens to that? And what I would really like to see are studies that trace different histories. Like before I mentioned the cronut, it would be really interesting to see a story, history, and different potential trajectories of cronut, had it not been granted some sort of patent, right, in this case on the name. What would have happened to it? Maybe many more people would have just enjoyed the cronut. Maybe we would have had it also here in the bakery. Instead, we don't. And perhaps that's a sad thing. Right? So maybe it wasn't a good idea. But it would be really interesting to discuss this with some studies and data and seeing one case versus another and what could be arguments and really what are the social processes that we're trying to model there. I think if you think before also this volume, there was no inventory of all of these cases. So trying to precisely play them one against the other, it's relevant. And so we never really studied this from a systematic point of view, and probably we should, because there are lots of subtleties there.
Maybe other questions.
There are some other questions on anything else from the room, or any other questions wanting to be asked? I'll try to do one more. Is that okay? Yeah. Okay, so this is following up on a previous question in terms that you kind of touched on this. So in your opinion, based on that, how many cases covered happened because producer recipe writers were not aware or were aware of their IP and legal rights and chose to enforce or did not choose to enforce in your example? So it's the choice of the person to enforce on the chronot. They might not have done. So is that the interesting edge case here, I guess, is the thing to highlight?
If we are aware of cases where
people don't enforce, or they choose, they're either not aware of their rights to enforce, or they're not aware, or they choose not to enforce.
Many choose not to enforce because of this sharing, ethos, sharing attitude, right? Because if you share, IP is the contrary of sharing. IP is excluding, right? It's about monopolizing and excluding. So many are still driven by sharing purposes, and actually they are quite happy when they are imitated, because as Coco Chanel used to say, imitation is the
highest form of flattery.
The highest form of flattery, right? This is also true of many chefs. But when the imitator starts making money, out of that, the flattery stops. And the annoyance comes, and and probably a willingness to do something, even illegally, might. As I said, the cases are not so many. There are so few. The other scenario, probably also the other scenario is true. Probably many chefs, they don't even know that they could protect it in some way, either if for a very expressive recipe with the copyright, or by using trade secrets, NDAs. But how can we really imagine chefs with the copies of contracts there? No, you cannot enter the kitchen if you don't sign this NDA because I don't want you to, See, but many don't even know what they could do with IP, right? Because of course it's very technical, especially the less famous ones. Probably the famous ones, they are well informed by their owners. Yeah. We have a question from.
Yeah, you're absolutely right. A lot of chefs are great chefs, but they're not business people. So I do think what they would love is the credit to them.
Yeah.
They don't understand what copyright is, and then to maintain it and put in the registration, let's say in the US. So the very well-known people like Gordon Ramsay, he's clued on for business. But if you talk about my great-grandmother who did a famous meatloaf, she would have no clue. So I think when, just crediting them gives them that approval or, feeling that they are known for what they've done.
And this is what copyright gives, because as you know, copyright gives also moral rights, right? Not only economic rights, moral rights. And one of these moral rights is the attribution right. The right to be recognized, the author, in this case of the recipe, if it's an expressive recipe, right? But even in patent law, there is a moral right, which is the moral right of the inventor to be designated in the patent application. It's a moral right. So, as imagine,
Yeah, and there is something else that I would like to get discussed. It's something we haven't mentioned. This the grant that we're starting, the specializing on recipes that the three of us are part of, and I think we have not gone far enough in exploiting the power also of professional guilds in this case, and maybe some other guilds. It could also be critics, for example, food critics or other food writers. So besides using IP rights, one place where one could go, and it's not necessarily there is that or there are consumers and social norms in the wild. There are actually things like professional associations. So every chef, if you're working here, if you work even for a dining hall, most likely you are associated to such a group or other, maybe more than one. And there might be people that write about you or that somehow regulate what you do. And those, it could be writing guidelines, professional guidelines for food critics, for food writers, for professional associations that should be suggested, taught in culinary schools. We're going to discuss this, I think, in the grant. That's at least for me an important route. We shouldn't expect consumers to know and to be able to tell, oh, but this was made by the other chef. But professionals know that. We don't need to go to law or to a court. Actually, a lot of disputes can be resolved by saying, you actually write to your guild or to some people that represent you, and you make them know that this other person is actually using a recipe that you have been using for years. You have probably proofs of that. And claiming that that's not what should be, what is in compliance with the guidelines that we all have shared. Right? I think that resolution, which is actually used in a lot of other professions, is something that is not exploited yet, or as clearly and explicitly exploited, but it's precisely one of those spaces of negotiation that is a bit more informal, but it's not totally informal. It's actually related to professional rules and guidelines. They're not legal, they're not IP rules, but they could play a very important role in this space.
Yeah, I mean, they just like to cook. They're not. You know what I mean?
And when someone sees that someone else is taking advantage of that, could point it out and say, look, this person should be featured on the menu. They are using that. They should say, okay, I'm doing that, but credits to such and such.
I mean, I help people set up businesses, and if I'm working with a fashion designer or a chef or something like that, they just want to do what they're passionate about, and they have no clue about IP. And you are right, there should be some manuals to educate them. I mean, whether they want to sit and be educated about IP until they blow up that somebody's taken the recipe, and that's another thing.
I've seen publishers suggesting that. As you know now, there are so many recipe books, and many of them really scrap from each other. They're unavoidable if you have to write a recipe for.
There are questions on this in the chat we did not get
exactly.
to. But,
that's exactly that.
Yeah, but again, thank you. Can we fit in one more if it's a very tiny one? And we're going to take one. We'll close this down, and then we can have a discussion afterwards. If I'm just aware that some people may have buses to catch and things like that.
Okay.
If that works.
I'll just ask if it's too long.
Yeah, that's good. Yeah.
I've been working in many food shops in London, and what I realized, I'm also Italian, it's that, for example, Parma ham is not really referred to prosciutto di Parma, but as a generic term meaning prosciutto crudo. And I'm wondering, when can that become a problem, that the actual name Parma ham will start to be generic rather than the UPDL?
Well, for example, the Court of Justice of the European Union in the feta case I mentioned before, there was also a Parmesan case, and the Court of Justice said, no, it's still a GI, even if it's the English translation. But in those cases, the Court of Justice said that we need to look, in order to verify whether a geographical indication has become generic, we need to look at dictionaries. As I said before, if your GI ends up in a dictionary, it's a bad news.
So for London, then we should be getting into the dictionary game. Nothing like as a blunder is what you're saying. Publishing a London free dictionary.
No, what GI owners or IP owners do when this happens is to write a letter to the publisher by saying, I've seen that you have put my geographical indications in the dictionary. Also, please also add that it is a GI owned by the consortium for the Parma. So if Parma ham ends up in a dictionary, it's a bad news, of course, because it means that this process has started. Of course, it's a process which may last years. It doesn't happen in 2 weeks, right? Then, so the judges, they need to look at dictionaries, market surveys. This is the most common method. For example, for the feta case, this was the main method. The Court of Justice relied on market surveys, which suggested that 95% of the consumers interviewed linked the name feta to particular areas of Greece. So dictionaries, market surveys especially, and common knowledge of judges if they are foodies, of course. But I think market surveys are probably is the most important one.